Good afternoon, everyone, and welcome back to Digital Law News, brought to you by Digital Law and produced by Anson Evaluate. So I'm here today with my colleague Peter Wright, and I'm Laura Spencer. Just so those of you are new here know, Digital Law is a law firm based in Barnsley, which specialises in legal matters relating to digital and technology issues. So things like data protection, cybersecurity, international data transfers and so on. So I'll just pass over to Peter to introduce himself.
Indeed, thank you very much, Laura. So my name is Peter, I'm the Managing Director at Digital Law, and we're very pleased to be able to bring you this discussion today. The intention is to give you a flavour of the sorts of discussions that we have in our meetings at the firm on a regular basis, and we wanted to give you a flavour of some of the issues that are topical in the sphere with regards to digital, legal and tech issues this week.
Yeah, so we'll start with the first one, and just to let you know as well, this is also available on a podcast on both Spotify and Apple and a few other platforms, I think.
Certainly is.
Yeah, so starting with the first one, so this has been a common theme over the last few episodes that we've been doing, and you might remember last week we spoke about how the Department of Health and Social Care had until the 8th of July to provide evidence that a DPA had been formed. So now it's come to light that a DPA actually wasn't performed, and the Open Rights Group have said that this omission means that the initiative has been unlawful since it began officially on the 28th of May.
Indeed, that's absolutely right. So under GDPR, Article 35, you're supposed to carry out a data privacy impact assessment, and it looks like that has not indeed been carried out. While on the face of it, that's a breach of GDPR, it's also a major failing by the government in not actually carrying out what it preaches, because GDPR is the law of the land, and any organisation building a system that's going to be processing personal data, or even has the possibility of processing personal data, you're supposed to carry out a data privacy impact assessment. I mean, the purpose of that assessment could even be to identify the fact that there is no personal data involved, so data protection then doesn't apply. But you can't do that unless you've got the DPIA to underpin the process and demonstrate, look, we have considered these issues. And this has been brought to light because there have been a couple of data protection issues around the operation of the test and trace system. We've had screenshots shared on Facebook of the details of people who are waiting for their tests. We've also had them shared in things like WhatsApp. And if the most rudimentary training had been carried out for the staff who are having to undertake this test and trace program, then they would have been told, don't share this sort of stuff on social media. Now, that would have been identified by a privacy impact assessment. You'd have worked out where the risk was, and the risk is our staff might share this stuff. How do you deal with that? You give them some training. So it's a fairly sort of straightforward, iterative process, but if the government isn't even therefore wanting to make sure that this is in place, what does that say to all of the other organisations out there handling personal data? You know, all of the entrepreneurs and the sorts of clients that you and I are advising on a regular basis, Laura, that we're saying to them, you need to carry out a DPIA, but then the government is responsible for processing huge numbers here of people's personal data, and sensitive data at that, medical records, details of whether you've had COVID or not. I mean, that's pretty sensitive stuff. And the fact they've not carried out a DPIA, it's a really poor example, I think, to the industry as a whole in terms of how you're supposed to approach the collection of people's personal data.
Yeah, definitely. And I think we was talking about this earlier. They are using the excuse that this is rolled out, this is really important. They had to roll it out really quickly in order to protect people's lives, basically. But like we said, there was a gap in between when they started. So when the whole coronavirus outbreak started in the UK, they started with this track and trace, collecting people's data, and then that came to a stop. And then, like it says on the slide, it began again on the 28th of May. In that time, they had the amount of time to do a data protection impact assessment, and they still didn't do it. So it does show a really big failing from the government.
It does, and funnily enough, one of the government scientists, Chris Whitty, appeared before the Health Select Committee, which is chaired by Jeremy Hunt, the former Secretary of State for the Department of Health and Social Care, this week. And the point was made that the infrastructure wasn't there to manage a proper test and trace system in volume in March, when the country, of course, we were faced with a flood of cases coming through. We didn't know where they were coming from. Some were coming from Asia, and then there were more that came through from Spain, Italy and France after the half-term week. And the system simply couldn't process the tens of thousands of tests that were necessary, let alone trying to trace the contacts. So the whole thing collapsed, and that was the time then and literally Chris Whitty was saying, we could not have carried on with the system. He made that quite clear. So, okay, we get the point that they couldn't continue with it in March, but that you've got the intervening period then to carry out your DPI when it comes back in May, and the failure to do that, as you quite rightly say, is not a good look for the government at all when it's handling all of this very sensitive, very important data at this time.
Yeah, I think it kind of undermines some of the guidance that law firms like us give to our clients. You need to do this when you start. If the government get away with not doing it, it could set a standard, really.
It does, and I think that the Information Commissioner is left in quite a difficult position in terms of how to regulate this properly.
Yeah.
Do they come down heavily on the government? But arguably they should. But I think this potentially goes to the heart of government and the attitude in number 10, which has clearly been throw resources to get test and trace back up and running. But when it comes to the legalities, as you call it, they've said, oh, it clearly doesn't matter. Now, you and I would say, no, this does matter greatly, because then you wouldn't have had people's personal data at risk. But clearly it's not been a priority for the people developing this system. And it's just a terrible, terrible example. How can we turn around now and effectively say to our clients, you need to do this, when the government at the highest levels made the decision, no? And I fail to believe that this was something that was just omitted. You've got to think that when you've got hundreds of civil servants working on this and advisors and politicians at the heart of government, they must have known that this should have been carried out by now. This isn't advanced stuff. This is basic data protection 101. So the omission isn't an accident. I think a deliberate decision has been taken somewhere, and that makes it very difficult for us to now advise clients on best practice.
Yeah, definitely. I completely agree. So moving on to our next one. Sorry, there was a spelling mistake on the screen, but that's supposed to say the EUUS Privacy Shield has been struck down by court. So a privacy advocate in the EU has challenged the agreement, arguing that the US national security laws did not protect EU citizens from government snooping. And in effect now the Privacy Shield has been revoked, and companies who are affected by this now should be starting to use standard contractual clauses.
Exactly right, and we aren't going to go into this in massive detail now because you and I, Laura, I think are going to be doing a longer discussion on this in a few weeks' time, really unpacking this, because we could spend the next hour discussing the Privacy Shield, as I've done with several clients over the course of the last few days. The long and the short of it is, and I think you were saying it was a spelling mistake, that was not referred to EU-US Privacy Shield on the title there, but the point is the thing's been struck down as no longer providing a safeguard for the transfer of personal data from the EU to the US. So all of those companies that were on the register, it's now no longer valid. So companies from Facebook to Nike to Twitter, all these corporations that relied on the Privacy Shield can no longer do so. So the takeaway, I think, for our anyone listening to this and watching this today is make sure that if you are sending data to a third-party organisation across the pond, make sure that that contract for that transfer of data has standard contractual clauses in it. Now, a lot of big corporations have said, don't worry, our underlying terms anyway contain the standard contractual clauses, so no problem. But this points to a wider issue and a wider problem with regards to data sharing between the EU and the US that is not going to be resolved quickly or easily. And for any organisations that are now building infrastructure and you're thinking, where should I have my data to store the personal data of EU citizens, the advice is very much make sure it is within the European Economic Area, which is an EU member state, or otherwise Norway, Iceland and Liechtenstein, which are also in the EEA, which Facebook, Apple, Amazon, they do have infrastructure located in the EU in the Republic of Ireland for that very purpose. So usually if you look in your contract with for the supply of those services, you should find that those standard contractual clauses are in there. But it's now, you have to make sure they're now in there. The fact that Privacy Shield has been struck down at the Court of Justice of the EU by Max Schrems last week means that you have to make sure it's there to demonstrate your compliance with GDPR. You have to make sure they're there. So that's the main, the main takeaway on this. And I think there'll be more news and analysis on this in the coming weeks. And we're already speaking to guest speakers to organise a webinar that will be going out. If you're interested on listening to this and attending that webinar, I think, Laura, we can safely advise people if they send an email to events@ansonevaluate.com, and we can make sure that you're then on the mailing list when we publicise details of when this webinar will take place.
If you send an email to that, or even to admin@Digital Law UK, we can then add you to it. We will be posting more information about that on social media when the line-up and everything has been confirmed. So moving on to our next one. This one is Data Protection Associations introduce a survey and representation concept. So there is a new initiative that is being developed. It is intended to represent UK-based data protection officers to provide insight into the development of the privacy industry.
Indeed, and I think it's quite an important step to take, given that UK data protection officers are now kind of on their own to an extent. They can't benefit from some of the pan-European structures where potentially, well, we are outside of the European Union, so we're outside of the formal structures of the European Data Protection Board. And therefore, when it comes to the development of the privacy industry, best practice and standards, I think it's incredibly important that we've got initiatives like this to spread best practice and allow a bit of a forum as well for data protection officers to be able to exchange their views, particularly when we've got new apps, new systems, new ways of developing the use of technology all the time, particularly when we're in a world where the 5G and the Internet of Things, IoT, means that even more personal data is going to be processed at an exponential rate, everything from smart watches to smart items around the house, all collecting and processing personal data. Therefore, it's going to be really important that this insight into the development around the industry can be facilitated.
Yeah, definitely. I think it will take a bit of pressure off the regulator as well, because they can spend more time dealing with issues rather than helping the actual DPOs and giving them advice. This will hopefully help them a lot.
Yes, I think so.
So moving on to our next one. So do you know how to pronounce the name, Peter?
That's putting me on the spot. Margarita Verstappen.
Yeah, so Marguerite was 100% correct over the public mood when it comes to the Apple tax case. So back in the early 2000s, Ireland actually gave Apple a sweetheart tax deal, as you say, and meaning they didn't have to pay much tax on the profits they earned. So basically, the European Commission have now stated that they want the Apple to pay that tax back. However, there was a judgment in court the last couple of days saying that the European Commission did not have the power to do so.
Indeed. So it's basically saying that the European Commissioner there, Margarita, was tapping into the public mood that was not happy with big tech firms not paying their tax, which was the reason why the Commission then felt, well, hang on, Ireland had given Apple this very favourable deal. When you think that corporation tax generally ranges in around that sort of 15% to 18% to 20% plus bracket. The deal that they'd given Apple, I think, was in the single figures, very low. And therefore, the Commission said, well, hang on, it's unfair. Apple is this massive, wealthy corporation. They therefore backdated a claim to say not only should you increase the level that you charge Apple now, but also you backdate it over the course of the best part of 15 years, and therefore presented Apple with a massive tax demand for hundreds of millions of euro. And not surprisingly, they then contested that decision, and they found that it was almost an overreach by the European Commission to demand that Ireland as a member state try and apply that, basically take away their ability to set their own corporation tax, which of course is a main lever that member states have to make themselves appeal to corporations and be more attractive places to go and do business. So, I mean, that was how in the early 2000s the Irish economy was seen as the Celtic tiger. It brought in a lot of tech companies into Ireland. It created a lot of employment opportunities through being able to make deals like that. And in effect, it was Europe turning around and saying, no, you can't do that. But at least with this decision, it's now rebalanced and said, you can't do that, even though arguably it was actually mirroring what the public actually wanted, to be heavier on the tech firms like Apple when it comes to them paying their tax.
Yeah, but I suppose now it just depends whether the European Commission come back and change the law on issues like this.
Exactly, and I think there is also a growing realisation amongst the tech firms that while it's very much a sort of corporate culture to be able to get away with paying as little tax, not just corporation tax, but various other things, other types of taxes, they always try and run their affairs in the most tax efficient, therefore paying as little tax possible manner as they can get away with. And there comes a point where there becomes a public pressure to say, no, something has to be done about this, and governments therefore start to get a little bit more reticent about cutting them the slack that they might have done in the past.
Yeah, definitely. So moving on to our second to last one, I think. So this one is regarding some tweets. So the court orders a barrister to deliver up tweet details. So the High Court over the last couple of days have ordered a barrister to disclose messages posted on a now dormant Twitter account, as well as details of who has access to it, in order to assist potential victims of alleged libel and harassment claims.
Yeah, so this is quite interesting from a disclosure perspective. So the High Court here ordered the individual who controlled a Twitter account to disclose the contents from the inbox of that Twitter account, because there were issues with regards to whether there was material in there that could assist potential victims of alleged libel and harassment that had been committed on the profile on Twitter itself. And this is an example of the legal system trying to apply itself into the world of social media. We've already had the service of legal proceedings has been affected on a Facebook account once, where they couldn't actually identify who the individual was. So, they couldn't work out a phone number or a home address for this individual. So they said, yes, you can serve details on a social media account. In this instance, we're saying that an order is given to say you have to now disclose the information held within this Twitter account as part of a wider action where they're then seeking to assist the victims of that alleged libel and harassment. So this continues to happen where you have courts trying to make these orders. interesting to see if it can actually be enforced would be the next step. It sounds like it will be enforced fairly easily, but you do sometimes wonder what happens where you must have the two irresistible forces moving against each other. And if it turns out, for example, that the barrister cannot, for technical reasons, access that dormant Twitter account, well, what happens then?
Yeah.
Becomes the question.
Yeah, definitely. We'll have to keep following that and update.
Indeed.
And this is our final one. So 340 GDPR fines have been issued under GDPR so far since May 2018, coming to over €1 million. Is that €1 million? Yeah, 100 million euro. The largest fine was on Google in 2019, and that was issued by France, the French regulator. And then there's some more information on there, with Spain being the most issued fines. And the main thing that we wanted to speak about today was the fact that all these fines have been issued, yet the ICO have still not issued a fine on British Airways or Marriott.
Yes, I thought this was a useful update for people to be able to see, because crucially, there have been a lot of articles written, because we're now 2 years on from when GDPR came in, and quite a few articles have been critical about the way that GDPR has been enforced. And the reason for that is, of course, we've got different countries have different data protection regulators, and each one is seeking to enforce GDPR in its own way. And indeed, there is still variation of how GDPR works in relation to the fact that individual nation states, member states, are able to apply those derogations in the ways that they seem fit. So GDPR you get in the state of Bavaria is going to be different to the one that you get in France. And that indeed is then different again compared to what you get in the UK. The UK has left the EU, but has written GDPR into UK legislation with Data Protection Act 2018. I think it is noticeable that those big headlines were earned for the fact that British Airways and Marriott were fined, and they were fined hundreds of millions of euros. So if both of those fines go through, that figure of 158 million doubles overnight, basically. Such is the sheer scale of those fines. But why have they not been paid? Well, they're being appealed, and there's a question mark. Arguably now, when you look at the fact this is BA and a large airline and a large hotel chain, both of which will have suffered severe economic consequences as a result of the global economic slowdown in relation to the COVID-19 pandemic. And it's a big question mark over the fact that even if they fail with their appeals and the ICO says, no, you've still got to pay, or certainly the fact that they have committed those breaches will continue to stand.
Yeah.
Then I think that will they ever actually pay? I think they could end up then saying, well, look, we've just grounded our whole fleets and we're making thousands of staff redundant. We simply cannot pay fines of that size, which then brings the whole enforcement matrix of GDPR into question. So what I think is noticeable with this review, though, is the fact that it's Spain that's been the most prolific. Lots of fines, just not in the region of the hundreds of millions that some of the other regulators have done.
Yeah. I think this relates back to the issue with the government with the DPIO as well. It does show that coronavirus is having an effect on how the ICO is actually working, because it just takes to wonder whether the ICO will take the approach as a breach, or whether they're breached but they can't afford it at the moment.
And I think it's a really important time for the ICO, because as of January 2021, we'll then be at the end of the transition period. It's then up in the air in terms of the data protection regime that the UK government wishes to follow. We don't really know for sure what that will look like. Will data protection be something that's at risk when it comes to the UK's trade negotiations with other countries? Who knows, frankly. So it's quite, in terms of the ICO's direction and strategy, their enforcement strategy in terms of how they're going to police GDPR is really important. I think the fact that we've not got that certainty on those BA and Marriott fines, and don't forget they've been around for a year now. I think, Laura, you and I were at a conference in Poland last year when these fines were announced. So yeah, indeed, that's 12 months on now. We've been waiting for this, and it's just stuck in the, the eighth circle of hell. It's still going on. We don't know if they're actually going to be successful in those appeals, or if they'll ever end up paying a single penny in settlement or not. So, 340 GDPR fines, but you can argue across the continent of Europe, you might have wanted to see a bit more enforcement in those 2 years than we've actually seen.
Yeah, definitely. Yeah, that will be another one that they'll have to closely follow, whether the BA or Marriott actually do end up getting fined.
Absolutely, and indeed it's also important to see what other action they take, how closely they decide to apply their own codes of practice, and I think it's watch the ICO very, very carefully over the next 12 months.
Yeah, definitely. So we just wanted to move on to the final slide now. So Peter, I'll let you explain this.
Yes, so we have a special offer just for you, our watchers and listeners to Digital Law News. We have a GDPR compliance manual which contains forms and templates and checklists. It's designed for law firms, but we've had some of our clients who are accountants and others in professional services, financial services, who've gone, yes, we'd like to have a copy of this. And this was £195 when we first published this. And we're now offering it as a special offer to you, our listeners, for just £99, which is 50% off, of course, what we were originally charging for it. We have those hard copies that you can see there in the photo. We also have digital copies available, and it's just an extra £5 then for the postage and packing for the hard copy. But that then means you've got those forms, templates and checklists that can help you when it comes to applying GDPR good practice and being able to demonstrate compliance across your organisation. The GDPR manual, in particular for law practices, reflects the risk and compliance matrix that the SRA demand is in place anyway. So we don't put extra checks and balances in your way. Instead, we tweak some of the things that the SRA is saying you should be doing anyway to then make sure that they also relate not just to data protection, but to other things. So, for example, when it comes to auditing a file, you're auditing the file for everything from anti-money laundering to other compliance measures, and we just add in a data protection section to that. We would replicate that across loads of different things that you're already doing. So hopefully we'll make life easier rather than more complex is the message to take.
Great. So I think that's everything for today. So as Peter said, if you do need any more information about the manual itself or about any of the things we've mentioned in today's webinar, you can just give us an email at admin@digital-law-uk. So as Peter might have mentioned, the webinar is now available as a podcast as well. So that is available on Spotify, Apple Music, and other platforms like that as well. So thank you for listening.
Thank you. Bye.
Thanks. Bye.